Welcome to Doing Divorce Different. I'm happy to have you here, and I'm so blessed to have Melissa Miroslavich with me. I love saying your last name. It's like a hard one that I actually think I get.
You do. You did a nice job.
So, and here's the thing, Melissa is an awesome attorney. She works in Minnesota. She does some family law, she does estate planning. Are you still doing family law,
I also
estate?
do estate planning. I do prenuptial agreements, so that's the part of family law I do.
Yep.
Pre-planning kinds of things and business succession planning.
Yeah, which we really love for today because I told Melissa I wanted to have her on because I've had some clients coming to me who have questions on both sides of divorce. If they want to stay married or if they're thinking about divorce, on how we can protect the assets in a marriage. And I'm going to let Melissa kind of take over and explain ways. And then I'm going to jump in with my scenarios to see how this actually plays out. So, Melissa, welcome. Thanks so much for being here. Thanks for sharing all your knowledge because you have a lot and I appreciate you.
Oh, thank you. I'm happy to be here. Yeah. So protecting assets in a marriage, I guess it depends on what the end is for the marriage. Like, what are we protecting them from or whom? And so, if you think about a marriage, and marriage ends in one of two ways. It either ends in a divorce or it ends in a death. And so, life happens and things can get complicated. So, one of the ways that you can look at maybe when we're talking about things like this, like a yours, ours, and mine, like yours and mine and ours assets in a marriage in Minnesota, a lot of those assets are assumed to be ours. And so when we're looking at a divorce, for example, those assets that are considered ours by the statutes tend to be broader than maybe what people think if they don't know that. And so one of the ways that you can sort of protect what is yours versus ours or mine versus ours is actually doing a prenup before you get married.
Mhm.
And that's a really important step that I like to do because I feel like it makes a stronger relationship. And you also go in with your eyes wide open, and there's a base understanding of what could happen in either of those scenarios, meaning death or divorce. And so a prenuptial agreement can say, hey, we like those laws and we agree with them. And it sort of stamps in time what you've brought to the relationship and to the marriage. Or you can say, hey, I don't want to do it that way. My fiance doesn't want to do it that way. We want to do it some other way. And you can make your own private agreement, basically. And there's lots of rules about how those work to make them really strong and valid, but that's one way to do it. If you're already married, you could do a postnuptial agreement. Postnuptial agreement is saying, hey, we're already married, but these are some of the things that we're concerned about. This is how we feel about it now. And we want to do a yours, mine, ours kind of scenario. You can also do that after marriage. There's different rules associated with that in Minnesota. The specific two that are important probably is that you both would be required to have an attorney, which in my opinion makes a lot of sense because at that point in time, you have spousal rights that you may be choosing to give up. And you want to know what those rights are before you do that. And you also, once you sign it, it's not actually truly enforceable for 2 years. So there is a period of time where you can't just like make an agreement and then a week later get divorced. So that doesn't make sense. So that's one of the protections that the statute have in place for you. So postnuptial agreements, prenuptial agreements are great when we're thinking about divorce scenarios. You can also handle death scenarios in those kinds of agreements. So those are super helpful. And then when we're looking at estates, there's ways that you can waive your spousal rights when it comes to an estate. And I will just say the longer you're married, the more the statutes would say as a spouse you are entitled to if your other spouse dies. So you can also waive those. It's stronger if you have a prenup and the waiver when you do the estate plan. So those are some of the vehicles that are available to you.
Well, and I love that. And I just want to say for listeners, because believe it or not, I have so many clients that come to me and they say, well, I'm just going to keep my car. He's going to keep his. And this is in my name. We've already divided everything up. And I think what they're not understanding is, no, you haven't. You know what I mean? Especially in Minnesota, Wisconsin, I've worked in a little bit too. Um, what you own in that marriage, you own together, and it doesn't matter whose name is on it. And so I think that's why that prenup is so important. I don't think people understand the power of the bond of that marriage. It's like starting a business together, and that's why this is so important to the listeners. You need to know, that you've gotta set this up differently if you want a different result.
That is absolutely accurate. And in Minnesota, we have this, it's sort of a short form of saying this, but if you own real estate, let's say you buy a house together. In Minnesota, you can buy a property individually in a married if you're married, but you can't sell it without your spouse's signature.
Mhm.
So we call that one to buy, two to sell. And that's something that's very important in Minnesota. And the reason for that is so that spouses aren't just left high and dry without a place to live, right? Nothing can get
Yeah.
sold out from under you when it comes to property. So different types of property is handled differently. And in a divorce, you can also come to agreements where you might decide like your car is your car, my car is my car.
Yes.
But as long as you're agreeing, right? It's when we don't agree that things get really long, involved, exhausting. Courts are involved, and judges start making decisions for us.
I'm glad that you said that too, because if you use mediation or collaborative law, you can do this how you want to, as long as you're clear. And I always kind of say, state a reason why
Mhm.
you're doing it that way, just so the judge knows, like, I know I'm not getting as much, and this is why I want it. You know what I mean? I don't know.
Yeah, this is why it felt equitable to me.
Yes. Yeah. Okay. All right. So let me ask you, I'm going to ask you about a particular case where I have a couple. They have a lot, kind of a lot of assets, and they've been married a long time, and they're divorcing. And during their marriage, husband received a gift, an inheritance that was just to him. And we haven't talked about this. We've said everything belongs to both of you, except for non marital property.
Exactly. We have the concept of marital property and non-marital property in divorce. That concept doesn't really exist in death, by the way. We can make it exist, but it doesn't really exist there. Yeah. So that distinction between marital property and non-marital property becomes like the most important thing if you're going through a divorce. And a prenuptial agreement can really be clear about what is in fact non-marital property, which does not get split. That's why that's important, versus marital property, which does get split.
And so, in general, Melissa, can we say that if you get a gift or inheritance that's to you alone and you don't mix it in with your family, um, that can stay yours? Or, like, if you had a 401k before the marriage, you can keep that portion of it. Is that true?
And we start doing math. So yes, if you get an inheritance and it is only to you, so the check is literally to you, not to both of you, then technically that would be considered non-marital property. But what you do with it is really important, right? So if I get a check and it's non-marital property, it's an inheritance or a gift from my long lost cousin, and I put it into my joint account, I've now just basically gotten rid of the non-marital property part of that because of how I'm choosing to use it. Or let's say I get $100,000 because somebody died, and I put it into my own account, and I can show that this is what I inherited, this is where I put it, and I haven't used it in any other way. I basically have to set up all the dominoes because in Minnesota, the person who says something is non-marital property has the burden of proving that it's non-marital property.
Gotcha.
And if you remove one of those dominoes, you lose the non-marital property like protection, basically.
Right.
Mhm.
Okay. So so I back to my scenario.
Okay.
Went off on a tangent, a non-marital property. So we've got this couple. He receives an inheritance that is just to him. He puts that in in a trust, and in that trust, he purchases a home in Arizona
Okay.
that the family uses. I mean, I asked this, and they said, and the wife is even like, oh no, the financial planner said that's his because he put it in a trust. And I said, I don't know if that's necessarily true if he's using it. The wife and daughter go there and vacation there. I mean, I think he's kind of living there more now.
Sure.
But is that a way to keep your money safe from your spouse when you inherit it just by putting it in a trust?
Not necessarily, no.
I don't know. Let's dive into that a little bit.
Yeah. So, I guess the first question I would ask is what kind of a trust is it? Because there's lots of different kinds of trusts. So, if you set up what's called a revocable trust, versus an irrevocable trust is what we're going to kind of dive into here. Because when I hear the word trust, I start thinking, okay, well, who created the trust? What's in the trust? When was it created? Those are the questions I start to ask myself. So to make it very simplified, if you have a revocable trust, which is a tool we use a lot in estate planning, quite frankly, because it helps you avoid probate and has other benefits. If it's revocable, I think about it as you kind of own a shed in your backyard, and you can put things into that shed and you can take things out of that shed, and you have the keys to the shed. So you are in full control of the assets that are in the revocable trust and what you do with them. You can also change that trust. You maintain holding the keys, you're in charge, versus something called an irrevocable trust. An irrevocable trust is not like the shed in your backyard. It is basically like when you go to deposit a letter. Do people still write letters?
I do.
And you go to the mailbox. That's not your personal mailbox. Maybe that's a better analogy. It's not my personal mailbox. It's just the mailbox by the gas station or whatever. And I put things into it. I can't get them back. I'm not in control of it anymore. Somebody else is. That's more what an irrevocable trust is. So we might set up assets in an irrevocable trust. I might be the one who's feeding the trust. I might be the one who created it, but I'm not in charge of it. I don't have the keys. I can't make changes. It's really not mine anymore. It's really owned now by the trust itself. And the reason people do that, because you're like, why would you give up control? It's because they're looking for protection, right? So maybe we want protection from creditors, or we want protection for um, somebody in our family, or maybe we want a tax benefit. So Minnesota has estate taxes. Not every state does that, but we do. And one of the tools that we can use to minimize somebody's estate or make it smaller is to remove assets from the estate and put them in an irrevocable trust. It's no longer counted towards your estate. So there's reasons people would do an irrevocable trust. If you get an inheritance from a parent and they want you to be able to have benefit from that trust as a beneficiary, but they don't want you to have control over it, that would be a way to sort of separate out those assets, and they're not really yours until you get them as a beneficiary. Does that make sense?
Yeah. Okay. So in my scenario, I don't know for sure. I don't know for sure if it was an irrevocable. If it was irrevocable, though, how would he have used it to purchase a home?
That would be very dependent on the language in the trust itself. So this
Okay.
is now where you do a deep dive into, like, have an attorney look at the trust document and say what is allowed, what isn't allowed. But if he has control over those assets, I would be surprised that he is the trustee or the person who created the trust. Like, you, once it goes into an irrevocable trust, you lose control, right? So that would be a gray area for me, and I would want to question about that, because
Yeah.
if it's a revocable trust, we haven't protected the assets from the yours, ours, mine, marital property, non-marital property at all. It's
Right.
you're in control of it. Irrevocable would be like, it's not part of my estate. I don't have access to it. I can't get the money out of it. That seems like a scenario where you might be like, okay, so what's really going on with that particular irrevocable trust? Because just because you have one doesn't mean that it's not considered marital property. So that doesn't just automatically protect you. So say somebody knows they're getting divorced and they're planning it out, 3 years in advance or something, and they go create this irrevocable trust during the marriage. Depends on what money they used, because a court might look at that and say, yeah, that feels wrong, right? That just hits wrong, and so you might not be able to access that money, but you still might have to cover off the marital portion of that money,
Mhm.
and divide it equally anyway, even if you can't access it directly.
Yeah.
It's gonna be very case specific,
Okay. And so I like that. And so I feel like in that situation, absolutely the wife should have someone on her behalf looking at that trust and knowing, uh, to know what her rights are.
for sure. Yeah.
Yeah.
Yeah, I mean, I would always say, if it doesn't feel like, I always start with this, what does this feel like to me? Like, what's happening? And that first question is, who set up the trust? Who's in charge of it? Who has access to it? What's in it? Where did that asset come from? When did it happen? Was it pre-marriage, after marriage? All of those factors are going to play into whether that asset is now considered marital property or non-marital property.
That was my thinking, and it was during the marriage, so to be determined.
Yeah, what I'll say is that a judge would not just assume that
Mm.
they're not gonna ignore the asset, right? They're gonna question it, they're gonna look at it, they're gonna ask similar questions to what I asked, which is very different from what the IRS does, just in case you're wondering.
Should no,
You
good
know, they're
no.
more like a creditor, right? So different strokes for different folks.
Right. Right, right, right. Okay, okay, that's super helpful. You're helping me out, you're helping the listeners out. Now I have a different scenario. And interestingly enough, I'm helping someone right now through this, and this isn't the first time. So I feel like, well, there might be some other listeners who are going through this. So I'm going to tell you in the past, I had a lovely couple. They had been married a long time, and he had an addiction problem. And they came to me because he was afraid if he lost it again, he would spend all the money and he wanted to take care of her and his kids. And he was gone for, I don't know, 3 years and she didn't see him and he spent a bunch of money and they loved each other, but he just had a really so he was in a great place when they came and they worked with me and we did do a divorce for him even though they kind of stayed together. And that way she was able to separate out the finances and she was safe. And god darn it, I talked to her later and he did lose it again and was gone. And so we were so thankful. So, let's fast forward to just recently. I've got a young couple kind of in the same scenario. And I feel protective, a little protective of mom and kids. Um, and she doesn't want to get divorced. She has hope. And so we're trying to look at, and I'm trying to come up with ideas like, okay, you can always get divorced and stay together. That's one option. You can do a legal separation. And that the laws are a little bit different in Minnesota and Wisconsin. You, c- she was wondering if there's any way you could set up some kind of a contract. I believe that would be a post nuptial.
Yeah.
Can you speak to what her options might be? And he's in this with her right now.
Yeah.
He feels the same way. He doesn't want a divorce, but he wants her protected because he knows it's scary.
Yeah, I mean, I feel like you're kind of hitting the nail on the head of what the 3 options would be. So you have the first option. Well, let me give you worst case scenario first option, right? And I will do this from my own experience. So I did practice family law. I chose to focus on estate planning, but I did have a client who spouse had an addiction, and they were together. I want to say 20 plus, maybe 20 plus years, enough for the kids to, like, be out of the
Mhm.
house-ish. And, at that point in time, we did a divorce and lots of assets had been misused, and, um, there's things that you can fight about when there's misuse of marital assets and things like that, but that again, that's expensive and drawn out, and nobody really wanted that in this particular case. And, for me, in the attorney role at that point, it was really hard because I felt for the situation. Um, Everybody's concerned and is worried about the money. There's no getting the money back once it's gone, to be honest with you. Like,
Mhm.
that's not possible. And in Minnesota, we're a no fault state. So we can't say we're divorcing because of your infidelity or we're
Yeah.
divorcing because of your addiction or whatever. So those are out the window. And there's good reasons for that. I'm not against that at all. But it was kind of a tough cookie situation because her choice was to stay, even though she knew that this was happening. And he had periods where it was great and periods where there was relapse and everything in between. And so that's a hard pill to swallow, I'll just say. But that is the pill that you sort of swallow at that point.
Mhm.
Another option would be to say, okay, we're both in a good place. We really do want to protect the assets. And how do we do that? I would be looking at a postnuptial agreement in that scenario, which is basically, it's kind of like a prenuptial agreement, but you basically sit down with each other and you say, okay, here's the assets that we have. I'm going to start shifting assets and saying that they're non-marital property and putting them in the spouse that isn't struggling with chemical health issues. and start separating those out so that we are able to protect the more of the assets, let's say, in the case of a divorce. Um, One of the benefits of that is that you get a nice clear picture of what the assets are and the liabilities. We do both because you have to have full disclosure of the financials in that situation. And once you sign that on the dotted line in Minnesota, it takes a couple years to actually make it enforceable. But you could also make an argument that it's enforceable before the 2 years, but you'd have to prove it and you'd have to win that argument.
Ooh,
I
so
also
it
think
took 2 years for that. I did see that, which may not be great in this scenario right at the moment. We don't really wanna wait 2 years. Okay.
well, you have to sign it and then you've got 2 years before it's basically like assumed
Uh-huh.
enforceable. So there's a period of time where it's not. And that is really meant for the benefit of the people who are part of this process because if you're making marital property non-marital property, because remember you're already married, so the rights exist, you have them. You're not in a prenuptial agreement, you're not married yet. So you're not giving up something that you already have, you're giving up something that you could have. But in a marriage, you might be giving up things that you already have rights to. And um, so there is this sort of period of time where it's not assumed to be enforceable. You could argue if you were in court that it is for a bunch of reasons, and I don't know if you would win that argument or not. That's very dependent on the situation, obviously.
Okay, so that doesn't sound like a great option in the situation with addiction, where you don't know timing. So it's good to know that that is, and I think I know like people who have done postnups they're maybe starting a business. You know what I mean? And they have a partner. And so they work that all out. I get that. And I understand the 2 year. That makes complete sense, because someone is giving up their rights. Okay. So kind of sounds like a separation or a divorce might just be the option.
That's probably the most protected, right? Because when you have a divorce or legal separation, you are separating assets, right? So, and that's a completed transaction, if you will. So once a divorce is finalized and it's effectuated, like the assets are going to the person they're supposed to go to, and based on the agreement that the parties make or what the judge tells you or whatever. So that's probably the strongest, right, way to protect financial assets. Um, with a postnuptial agreement, we do have this wiggle room of time before the presumption is that it's enforceable. Um, in addition to that, I would also be looking at an estate plan. Um, with addiction, there is possibilities for overdoses and all those kinds of things. So we start talking about death. Depending on how the estate plan is set up, I do know that there are people who are concerned if the person who doesn't have the chemical health issue dies first, and the person who does have the chemical health issue dies second, they've inherited potentially the whole estate, depending on how long you've been married and the family dynamics and kids and all of that stuff. But that's a scary scenario too. And so lots of times people will make a plan for, in the case of death, what's happening with these assets. In Minnesota, your spouse has a certain level of rights to
Mhm.
the assets of the estate. And so you can work your way around that. One of the ways to do that is to do a combination of a postnuptial agreement as well as waivers and consent to what we call in Minnesota is your elective share. So a spouse gets a certain amount. The longer you're married, the more you get. And lots of spouses just give everything to each other. So most people, it's not necessarily on their radar that that's what happens. But there is an elective share component to this that you could waive your rights to, but you want to sign waivers, show consent, like you want it documented that that's what's happening.
Okay, so you're kind of saying that for if you take the post-nuptial route. So now let's just clarify too for the listeners, if you get a legal separation or a divorce and you separate those assets and oops, you had a will and you forgot about it, does that null after you've been divorced?
So in Minnesota, we have laws that say with divorce, the day that judgment decree is signed by the court, that there's a severance. Basically, we're severing the role of spouse. And so even if you named your spouse as your beneficiary in your will, if you are divorced as the date of the divorce, spouse is no longer eligible to be the inheritor or your personal representative or your trustee or your power of attorney. So there's an automatic moment in time where those are severed. Um, since I do estate planning and I'm very much about proactive thinking, I will say even though that severs automatically, I think it's really important to make sure you pick the people you want because we'll just go down the line and who was next. And maybe it was your spouse's brother and that's no longer appropriate, right? So, or maybe it is. I actually have I've had several, especially in the collaborative process, people who are divorced and their spouse has been severed from those roles and they still want them in those roles. So
Mhm.
when you talk to me about people who are divorced but are actually still together and they still like the protections and the person would make good decisions for them, I will after the divorce severs their role, I will go and reinstate them sometimes.
Yeah.
Maybe not as often as other cases, but it does happen occasionally.
And especially in collaborative law and mediations where people are working together, which I think is the best way if you can. And then I just want to add one other piece. When you get divorced, and if you have beneficiaries set up for like life insurance, does that automatically sever or would that still
We
go
don't
to out?
honestly check our beneficiaries. Let's just yeah, like rule of thumb, let's just check the beneficiaries because we do get into like, wow, that could be an interesting argument, right? Or an interesting fight. So once just to be clear in Minnesota, if you're in a divorce process, you cannot change your beneficiary designations. That's not allowed unless everybody agrees. After the divorce, then you can. So there's that time period where you have to be careful. One of the benefits of doing a prenup, since we did mention them earlier, is that you can change that rule for yourself. So in lots of prenups that I do, we change the date. We don't say you can't change your beneficiary designations until the divorce is finalized. We say if it's started, you can change your beneficiary designation. So there's lots of different nuances to the prenup that people can benefit from, even if they agree with how things would get separated.
Right. And I just okay, so on a point I was trying to make though is that if you get divorced and you have your spouse as the beneficiary of like your life insurance and then you die, it goes to your spouse, correct?
Let's change that. Yeah.
Yes.
Yeah.
So
Because there's
the
no
will ends, but
there's
not
no
the
for yeah. So the statutes will end it for wills, trust, powers of attorney, executor roles, that kind of stuff. But those beneficiary designations when you're working with big companies, they're great tools because they keep you out of probate court. But yeah, we need to change those beneficiary designations
yeah.
when it's appropriate to do so.
So much to think about. That's why, I mean, I got to tell you, I love AI. I love it. I use it every day. But I have had people coming to me and thinking they know everything. It's just hard. You do need a little bit of help, a lot, or, just get informed on what you need to do as best you can. Because there is so much. I mean, I'm like, okay, we're at our time now. Like, and I feel like I thought this was going to be a quick little no, but these are really in-depth things, and I'm so thankful you clarified things I learned. This is gonna help my listeners, so I so appreciate you. I know I'm gonna have you back on because
Hey,
I love having you.
yeah, I'd love to be back. Hopefully, we shed some light at least to know that there's like things you can do. I don't think there's a solid best fits everybody answer to that question. I think there's a lot based on the individual circumstances, which is one of the reasons I like working with families because everybody has their own things that they bring to the
Yeah,
table. Yeah. So
yeah, and so I would highly recommend you to my listeners if they're in Minnesota and we'll have your, contact in the show notes, but
okay, great.
otherwise, Melissa Miroslavich, how can they reach you?
They can go miroslavichLaw.com if they can spell it, but it'll be right there.
I'll have it in the show notes too. But if you're thinking, oh, I'm getting married, I want to talk about the prenup, or if you're thinking about even just thinking about divorce, I don't think it's a bad idea to touch base with you to find out, okay, how is this? What do I need to be thinking of? Because sometimes, darn it, that family law attorney isn't always remembering those things.
That's true. That's
So,
true.
yeah. So,
It's true.
all
Absolutely.
right. Well, Melissa, thank you. I appreciate you. Thanks so much for being here.
Thanks for having me. It's good to see you again. Bye,
Yes.
Lisa.
Care.